So with that, we've got a few minutes remaining. Maybe ask the panelists just what are a few takeaways that on what you talked about or what we've talked about that you try to convey. What's important? Larry?
As long as my share of the slides are up, we can just finish
They're
that.
at the end.
For the non-corporate entities, I think I've stressed this before. There are fiduciary duties that don't assume that they're gone, but you can make them gone, and you can modify them, and as we saw, you can use substitute provisions that will be dealt with as matters of contract and operate in some way to achieve something that looks like fiduciary duties but isn't. The contract controls, however, and I can't tell you how many cases like that involve these entities where the court will say that might have been the case without a contract provision, and fiduciary duty might have operated this particular way, but here we have a contract that takes precedence over everything. And so, as I said before, a lot of these cases involving limited partnerships and LLCs have become contract interpretation cases as opposed to fiduciary duty cases. The one thing I spent some time focusing on with Diekman is that there is this non-waivable implied contractual covenant of good faith and fair dealing, and as I said before, I think this is really a tool to deal with the wise guy or the wise guy argument, which is kind of what I thought Diekman's defendants were really making.
But it's a
You
limited.
really think you can lie and cheat?
It's a limited sword, however.
Yes, it is a very limited sword, as we saw from the subsequent HCP case. As far as defective corporate acts are concerned, there are things you can't do with 205. You can't invalidate an act. You can't validate an act that hasn't been taken. And this View case demonstrates that you can't use it to validate a transaction that has actually been rejected, as opposed to simply, whoops, I forgot to authorize it.
Until now.
No, I think the view is the court's still not going to.
The court's still not going to do it.
I don't think the court's going to do it.
And I think that's true under both 204 and 205 on these points. Self-help or looking to the court to help you. Tom?
Just one question for the panel. After Dell and Aruba, is it possible for a deal that passes fiduciary muster to result in an above deal price fair value award?
Well, I think if it passes fiduciary muster, that goes to the process point, right? So you've had a good process, then the court should
Well, not
look
necessarily.
at
It might mean that you have a negligent process.
You said it passes
Fiduciary
Yeah,
muster.
it depends on what you mean by fiduciary muster, in other words.
I was thinking that we.
No,
As long as it's not grossly negligent, it's okay.
You're talking liability. The question is, does the process have the integrity that entitles it to respect?
Exactly. Yeah. So that you would look to deal value as an indicia of fair value. So if they did, and if what you mean by passes fiduciary muster is the same thing as is a process that the court respects to look for to fair value as a or deal value as an indicia of fair value, then no, I don't think you would have an appraisal award that exceeds the deal price.
And so let me just ask it a different
Unless
way.
you had negative synergies.
There seems to be this suggestion out there, and I think it came out of the recent AOL decision, where the process needs to be Dell compliant. And if it's Dell compliant, then the court should defer to deal price or less synergies or trading price. And it's in AOL it was not Dell compliant, and therefore the court conducted a DCF analysis. But
because it didn't view the market there to be a reliable market
Right.
price.
correct. But being Dell compliant is seemingly way better than simply passing the minimum threshold to beat back a fiduciary duty suit.
Sure. You can have a negligent sale process, something short of gross negligence, whatever that actually means, but I would claim that if it's negligent and wouldn't pass muster under Revlon if that standard were applied, I don't think it would be DEL compliant.
I was going to hoist Tom on his own petard. Pre-approval or injunction measured test of compliant, not liability measured test. If you would pass Revlon before shareholder approval, then that would be DEL compliant.
So there's your answer.
From a non-Delaware lawyer. So. Tricia?
I don't have such a thought-provoking question. Takeaways for me, I guess, would too. I really don't think we can overstate the utility of 204 and 205. They come up in so many situations where, I mean, you thought you did a stock split, but you never declared a dividend or filed the charter amendment. I mean, really, there are just so many places where it comes up, and we see a lot of them. And so to the extent you are going through and doing diligence either for an IPO or selling a company and you come across these issues, they really are useful and provide source of comfort for giving opinions for the buyer and buying a company as you're getting a company ready to sell. There is a lot of utility there. And I think the other piece is really keeping an eye on, to the extent you are representing a company with a controlling stockholder, and keeping an eye on a couple of things. One is recognizing, as I said at least once or twice, that a controlling stockholder may be somebody who owns less than a majority of the outstanding shares by the way they act, by the way they've populated the board, and how, whether they are dominating. I think that all goes into the mix. And then to the extent you agree that you have a controlling stockholder and you're doing a transaction and you want to set up a special committee, really make sure people understand that just because somebody is independent for stock exchange purposes doesn't mean that they are independent for Delaware law purposes. And people miss that all of the time. And you really need to, and our courts take a look at what are the relationships that these directors might have with the controlling stockholder. And I think our law is, we didn't really get into this much today, but I think our law is evolving a little bit on director independence. And I pointed to the Elon Musk case, and the court found there that one of the directors had been given sort of the prototype or one of the first cars that rolled off the assembly line, and the court said, yeah, at least at the motion to dismiss stage, wasn't quite convinced that director was independent, whereas otherwise the director appeared to be independent. So I think that's something else to keep an eye on as well, because people are surprised when you say, well, we're going to interview all of the special committee members to make sure that we're satisfied with their independence, and they push back and say, but they are for stock exchange purposes. It's surprising to folks. And so if you find yourself in that situation, really try to vet the special committee members, whether you are company counsel and starting to set up the committee, or whether you're special committee counsel. It's helpful to go back and do that again.
Well, and I guess my takeaway is to thank our experts from Delaware for sharing their knowledge and wisdom with us, and thanks to the audience for doing this with us. We enjoyed it. We hope you did as well. Thank you.